Well, hello there and welcome to the Disability Law Show. I'm John Scholes. He is Sivan, Tumarkin, and James Fireman once again. 1-855-821-5900 to reach out anytime. You want to send along an email. That is help@disabilityrights.ca. More stuff, more contact to give out as the show goes on. But guys, we've got a busy show today, so we'll get right into it. Coming up a little later, the top 3 things you should absolutely not tell your adjuster. That is on the way. James is going to talk about that one, Sivan as well. But we always start with the week that was, brother. What's happening this week? I think you got an email, correct?
Yeah.
Okay.
I'm going to read something to you.
Cool.
And you know, I want to tell you, John, generally on the show, we start off by saying, you know, I talk about an interesting case, somebody I've spoken with, an individual that's been cut off long-term disability or whatnot. But, you know, we also get contacted by treating practitioners, doctors, physiotherapists, psychiatrists, people who are treating these individuals who legitimately have claims for long-term disability. And the treatment providers themselves are at a loss as to what to do with these insurance companies because they're not listening to their opinions. So I'm just going to read you an example of something that I just received recently, just a few days ago. This person is from Ottawa, so we do a radio show as well, and this one plays in Ottawa. And she writes, I'm a physiotherapist, and I was listening to the broadcast on Sunday night with Sivan Tumarkin and James Fireman. I was in my car, so I was unable to record or take notes. It was the most informative hour I have ever heard on the show. All discussed apply to our dealings with MVA and LTD patients. MVA being motor vehicle accidents, and long-term disability patients. And then she's asking for a way of obtaining the hour, the recording itself, exactly.
Podcast.
And so, you know, 2 things. So you're going to give out the information where people can actually go and see these shows, past TV shows and radio shows, because all this information is out there on our website. But I also want to talk specifically to treatment practitioners, whether you're a family doctor or a psychologist or a physiotherapist. We would be more than happy to speak with you if you have general questions about this topic. I know there's an immense amount of frustration out there by these treating practitioners, by yourselves, when you're dealing with insurance companies, as well as if you would like us to speak with any of your patients. You know, we'd be more than happy. Again, there's no obligation. We don't ram this down anybody's throats. We are here to provide this information. We're here to, even the playing field of information for individuals, for treating practitioners, with these insurance companies who really are out there to make money, not to do what they're supposed to do, which is to pay out legitimate claims. So again, if you can give out the information, that'd be great, John. All of these shows are on our website.
Yeah, the other thing I should really add here is, if someone's out there and they're looking at this very cynically, they might think that we're talking to treatment providers and suggesting to them, oh, here's what you can say, and that's for sure going to be winner. That's not what we're doing at all, nor do we want to hear that from treatment providers. We are looking to get honest opinions from treatment providers, and if your treatment provider is telling you that you're not disabled, we're not going to do anything to try and change their opinion. So if you want to call us for some help on how to navigate the process, we're happy to do that. But nobody's going to lean on a treatment provider and suggest that they should change what they believe. Treatment providers, doctors in particular, have an obligation, and they have to do things honestly. They have to do things on the level, and we would never, ever get in the way of that. What we will do, though, is we'll tell them where the pressure points are, where the things are that they can emphasize, the things that are actually wrong with their clients, that they can write about in a report that will help to get them the benefits that they are entitled to. We're never going to tell someone that they should change their medical opinion because that's going to help a legal case.
I'm still stuck in the most compelling best hour of radio ever. I mean, that's, that wasn't your wife who wrote that, was it? I'm just checking.
I'm pretty sure they were talking more about me than Scott.
Of course they were.
100%.
Obviously.
100%.
Disabilityrights.ca is the website that Sivan is referring to. Disabilityrights.ca. You can catch past TV shows and radio shows and find out where you can get them, listen to them, and watch them at your leisure. Pocketemploymentlawyer.ca. That's another amazing resource. There's a lot to do with employment, of course, hence the name. But there's also a lot of crossovers between disability and employment, which is why you guys have a firm that does both. There's also a section of the Pocket Employment Lawyer for disability rights as well.
That's right. So we created this online website, this online tool to allow people to get accurate information about their employment situation or their disability situation.
Yep.
And oftentimes those two are linked. People are having employment issues as a result of an illness or an injury or a combination of both. And, they Google this stuff because just like, you and I, when we have any issue, we go to Google and we type in the question and we hope to get the correct answer. But there's so much misinformation out there. And there's so much contradictory information by people who say, we know what we're saying. And, you end up looking at who that lawyer is, and that lawyer is a family lawyer, not an employment lawyer. So we created this thing, this website, and it's been used thousands of times, John, so far since we've launched it. Very, very popular, and it allows people an opportunity. It allows them not to necessarily call us or anyone else or contact us, but you just go there and just select a few key pieces of information or input a few key pieces of information that applies to their case. It literally takes you 20, 30 seconds to do. And then that website provides you with accurate information and answers about your specific case. Now, it's just a starting point, but it will tell you if you have, in fact, a case. If it tells you you have a case, it will explain why you have a case, and then you have the option of contacting us, but you don't have to. You don't have to. There's no cost to this. It's anonymous, and it's accurate. That is the most important thing. And I'll tell you, John, again, it's been used widely, both on the employment side and on the disability side. So if you have an issue with your employment, or you know someone who does, or with your disability case, by all means, go to this website, use it. You will see how effective it is, and you'll get accurate answers to your specific situation.
Again, pocketemploymentlawyer.ca is the website. It's absolutely free. It's anonymous. If you want to carry on and contact the fellows afterwards, you can do so. Top right, there is a little yellow Contact Us button you can press anytime. Email address, another good old-fashioned email, works as well. help@disabilityrights.ca. Guys, that's where we're going now. Brandy, first one for the day. Brandy says, a close friend of mine is on LTD, long-term disability. His adjuster is telling him that he will not get any benefits after he reaches 2 years because he'll need to find other work at that point. He's in his early 40s and a teacher. He suffers from mental health issues and is medicated for them. He can't be around kids and rarely comes and leaves his house. Every time he spanks, it's not that type of case. Every time he speaks with his adjuster, he gets more depressed and more anxious. He's supposed to be cut off benefits mid-January, so closely. His psychiatrist says that he's in no state to work in any job at this point, and I'm just wondering if you guys can help him.
Yeah, absolutely, Brandy, and thank you so much for taking the time to write the email. All your friend is going to have to do is give us a call. There's a lot that we can help your friend with, and if you are watching out there and you have a friend in similar circumstances or a family member that you care about who should be entitled to long-term disability benefits but has been denied or cut off, you can do exactly what Brandy has done here. Write us an email. We're happy to provide you information. It's completely free. We're happy to talk to anyone. The consultations are always, always free of charge. Now, to address Brandy's question here, so first of all, the 2-year mark is a really critical point in long-term disability claims. During the first 2 years that you're receiving benefits, the test for total disability, which determines whether or not you get benefits, is whether or not you can return to your own occupation. After 2 years, the test gets a little bit harder. It becomes whether or not you can return to any occupation that you're qualified for by training, education, or experience. And so there are going to be occasions when after 2 years, the insurer will be justified in cutting off benefits because the test has become harder. And for some people, they won't meet that test. But Brandy's friend that she's talking about is someone who's got significant mental health issues. And when you suffer from mental health issues, those are there all the time, and that really doesn't change much job to job. Depending on the severity, for a lot of people who have mental health issues, it doesn't matter what kind of job you're talking about, they're just not going to be able to be there 5 days a week, 8 hours a day on a consistent basis until they have significant improvement. And certainly when we're talking about someone who has difficulty getting out of bed, that sort of seems to me to be exactly the type of person who's going to have huge difficulties even after the 2-year mark, no matter what the job is. So absolutely, as long as your friend has the support of their treating psychologists and doctors, we can absolutely help your friend, no question about it.
It's amazing, too, because, I mean, they said right here, can't be around kids, and he's a teacher. I mean, that's like a welder who can't be around metal. Of course,
sure. I mean,
work.
Now, in fairness, this is at the 2-year mark.
Right.
So after the 2 years, it wouldn't have to be as a teacher, but if the person's having trouble getting out of bed, it really doesn't matter. You know, there is one other point I ought to address here, though. Brandy mentioned that her friend was getting nervous or depressed and anxious every time that her friend talked to the adjuster. Now, I'm not really clear whether Brandy's suggesting that the adjuster is somehow bullying her friend or not, or maybe it's just dealing with the process. But if it is a bullying situation, if you have an adjuster who's being particularly aggressive, it's really important to put in writing a request to get a new adjuster. Even if they're already saying they're going to cut you off, put that request out there and explain exactly why it is that you need the new adjuster, because you feel like you're being bullied, because the adjuster is being aggressive. You want to make sure that there's a written record of that and a record of you requesting a new adjuster be assigned to the file, so that if and when they do cut off the benefits, they can't deny that you had an issue not just with their decision, but with how they conducted themselves during the claims process.
And keep in mind, John, that as soon as we get into the picture, as soon as we are retained to represent Brandy's friend, that adjuster is not allowed to call her friend anymore. They have to go through us, and that's a huge, huge benefit, especially for someone suffering from mental illness. But just in general, you know, people, when often, I do consultations, whether it's by phone or in person, and, you know, I spend the time and I dissect the case and I explain to them, here's what we can do. You have a case, you know, the insurance company was wrong. Here's how we can go after them. And here's what I think we can get you at the end of the day, potentially this and that. You know, oftentimes what they hear is not really that. They hear, you are going to speak with the adjuster?
Phone calls going to stop?
Yeah, the phone calls are stopping, the emails are stopping. I mean, that is a huge, huge relief for them. And that is a guarantee. That is not a maybe. As soon as we are in the picture, those calls, those letters, those emails from the adjuster, from the insurance company, stop, period.
Okay, guys, we'll take a short break. Still to come here, the top 3 things you should absolutely not tell your adjuster. We'll get to that. 1-855-821-5900. Help at disabilityrights.ca is the email address. Lots more of the Disability Law Show is on the way. Don't go anywhere.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Alrighty, welcome back. Disability Law Show. John Scholes, Sivan, Tumarkin, James Fireman. As the topic for today, fellas, the top 3 things you should absolutely not tell your adjuster. Getting right into these. Number 1 is this, James, that you're generally feeling better than you are. You know, not in the moment, but generally. Language is so important here, isn't it?
Yeah, you got to be really careful with the words that you're choosing. If you start a conversation, the adjuster says, "So, John, how you doing?"
I'm good.
Most people are compelled to just say, "Yeah, I'm feeling good. Yeah, things are good." Don't do that. Don't be a hero here. This isn't about trying to make yourself seem better than you are, and certainly be very careful with the language that you're using. Now, on the other hand, I'm not suggesting that you should be dishonest at all, but just be careful. If your adjuster says at the beginning of the call, "How are you doing?" that's not just a simple greeting, or it may well not be. You should count on the adjuster recording everything that you're saying and putting that in the file. And so if you respond with, "I'm good," you better believe that there's going to be a record in the claims file that says contacted claimant. Claimant says doing good. That's what's going to be in there. And when taken out of context, that has a very different meaning than how it was probably meant when you just said it as a greeting at the outset. So be very careful about not just how you express about how you're feeling, but about all your conversations that you're having with your adjuster. And this is something that we always tell our clients to do, and our listeners and our viewers as well. It's really critical every time you're having an interaction with an adjuster. You should be writing down everything that is being said and sending an email as soon as the conversation is over, summarizing the content. Now, I'm not saying you have to have a verbatim transcript, but the substance of everything that is being said should be recorded and sent in the email so that there's a record of it, so that down the road, nobody can say that what you remember happening is incorrect.
Just jot it down. Ask for a moment to get a piece of paper and a
Absolutely.
pen, right?
Absolutely. Every single time you get a call from your adjuster, ask them to just please hold on for a minute. You just want to write some notes down as the call's happening.
Sivan, next thing you should absolutely not tell your adjuster is this, that you're not complying with treatments because you've simply given up.
Yeah, you have to be very, very careful, and not just in situations where you've given up. First of all, you should never give up. Remember that your relationship with the insurance company is contractual. We have to go to the contract to figure out what are your obligations as a claimant and what are the insurance company's obligations. Well, their obligation is to pay you if you uphold your end of the bargain. And part of your end of the bargain in virtually every policy I've ever seen, there are provisions that say that you have to have reasonable treatments and participate in reasonable treatments. Now, what's a reasonable treatment? Sometimes insurance companies take an issue or take issue with some of the treatments you may be getting or not getting, or their doctors may say you should be doing X when your doctors say that you should not be doing that. I'm not talking about that. I'm saying, if you tell the adjuster that you're no longer taking medications, if you're telling the adjuster you're no longer doing physiotherapy or going to your psychologist, there better be a reason for that. And you want to provide that reason. You don't want to say, I've given up or it's not helping me. You want to be able to tell the adjuster or to convey to the adjuster that you are still intent on trying to get better, because you have an obligation, not just under the policy, but in law, you have an obligation to try and get better. It's the principle of mitigation. You need to mitigate your damages. And you can't simply say, I'm just going to, lie back and just accept my fate and that's it. Because if you do that, the insurance company will use that against you. And they will say that as a result of that, they're going to cut you off. And you're going to say, well, that makes no sense. Well, it does make sense, because you have an obligation under the policy to follow reasonable treatments, especially if your doctors are saying, because remember, in your doctor's records, which will go to the insurance company, the doctors will record, and I've seen that, where a family doctor will say, for example, I've prescribed X, and patient says they're not willing to take it. You have to be careful of doing that. There has to be a rationale for it, and certainly there has to be a discussion as to, okay, if this doesn't work, what else will work? You can't simply give up.
Yeah, and I think it's really important to understand this isn't just about what you're saying, it's about what you're in fact doing.
Right.
So, saying that you've given up is obviously, a bad thing to tell your adjuster, but if you've in fact given up, that's much worse. So if you haven't given up, and if you're actually trying to comply with your treatment plans, then you have to explain how it is that you're trying and why it is that even though that your adjuster thinks that you're not, that you are in fact doing everything that you can to comply with the treatment proposal.
Using your medication example, maybe you're having a bad reaction, but look, I'm not taking it now, but I'm seeking another medication through my medical team to try to fix this. That's okay.
Sure, or if you're getting treatments from a particular provider and you've missed one or two because you had a significant illness, maybe you had a very high temperature and you just couldn't get out of bed, that's perfectly reasonable. That doesn't mean that you're being non-compliant with treatment, but you have to make sure that you explain that to the adjuster. You want to document any time that there has been any type of a break in what the proposed treatment is, and make sure that there's a record explaining exactly why, so the adjuster doesn't jump to the conclusion that you're just giving up.
Right.
There's a side note to this, which is interesting, which, John, we deal with these kinds of claims throughout Ontario and throughout BC. And in many instances, we're dealing with individuals who come from smaller jurisdictions, smaller towns, where you don't necessarily have all these doctors you have in the big cities. And so what happens if you have a doctor and that doctor retired, and now they have no one? Again, given that reality, you don't want to say to the adjuster, well, there's just no one here, there's nothing I can do.
Right.
You want to convey to the adjuster that you're doing whatever you can to try and locate a new provider. Again, that's all part and parcel of this obligation you have to try and get better. And to James's point, again, you want to do that anyways, irrespective of the legal claim, because you do want to get better at the end of the day. You don't want to be on this LTD forever. But it's important in terms of what you convey to the adjuster.
Top 3 things you should absolutely not tell your adjuster. Number 3 is this, guys, that you think you'll be ready to go back to work when your doctor advises that you should not.
This is very simple. When you are asked whether or not you're ready to go back to work, the answer is, I'll be ready to go back to work when my doctor gives me the approval to do it. That's it. It's as simple as that. Going back to work is a medical decision, and you might feel great, but if your doctor is telling you that you're not ready to go back to work, you have to rely on their medical expertise. Unless you yourself are a doctor, and even if you are, I'd be pretty hesitant about relying on your own feelings versus what your treating doctor is saying. Your answer should always be, I'm ready to go back to work as soon as my doctor gives me clearance to return. It's as simple as that. You don't have any feelings about it one way or the other. Now, you can answer specific questions about your relative pain level day to day and what have you, but when it comes to, are you ready to go back to work? I'm ready to go as soon as my doctor gives me clearance. Straightforward.
Yep.
So I want to make a slight point here, which is that even if the doctor says that you're ready to go back to work, again, in terms of how you convey that or how that's conveyed from the doctor to the insurance company, there is a difference, a big difference between this person is ready to go back to work and this person is ready to try to go back to work.
Okay.
Because try implies that we don't know what's going to happen. And we've seen situations where the doctor or the individual have said to the adjuster, the person is ready to go back, and the person tries to go back in good faith, and it's not working out. The illness or the injury is just too severe. The person is not ready yet, and they want to go back on LTD. And of course, in most policies, you have a recurrence clause, so it allows you to go back immediately on LTD. And the adjuster points to that letter from the doctor that said, but the doctor said that you're ready to go back, so we're rejecting your application to go back on LTD. So again, you want to make sure that you understand the difference between try to go back to work, it's a subtle difference, and you're ready to go back to work. I mean, ultimately, we can help you either way, but it's just something that will bolster your position in the event that the attempt to go back to work doesn't succeed at that point in time.
What are your options when your insurance claim has been denied? We'll get to that after a short break, so stick around. 1-855-821-5900. Want to send over an email that is help@disabilityrights.ca. This is the Disability Law Show. Stick around. We're coming right back.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do you do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back, the Disability Law Show. I mentioned the email address, help@disabilityrights.ca, or simply disabilityrights.ca is the website. You can catch past TV shows and links to the radio show as well. There is a third option, and that is mydisabilityquestions.com. You can ask your questions there. These fellows are a member of the team, will answer it, and there's a good chance that it has been asked before in the archives. You can search the archives for an answer as well. If not, they'll get to it. Guys, want to get to one here again, mydisabilityquestions.com. First one for today is this, probably the only one actually. Antonio says, my brother had a stroke about 2 years ago and went on short-term disability. He's still recovering and can't go back to his job as a plumber. He's been doing for over 20 years. His long-term disability insurer denied his claim last year, and he appealed it, but was rejected again. No shock there. He's looking to sell his house, and we're trying to figure out options. Can you guys help him? And if so, how long would it take? He's not doing well, both physically now and mentally.
Yeah, 100% we can help your brother, Antonio. And, you know, John, this is something, again, that we come across all the time. It doesn't matter what industry people are in. It doesn't matter what kind of disabilities they have. People come to us from all walks of life dealing with the same issues with these insurance companies. And we've dealt with all of these insurance companies. You know, they all act in a very, very similar way because they all have the same objective, which is to make money. And one of the ways they make money is by denying claims. Trying to shake you off claims, trying to get you to appeal and then deny you again. So you know, when I see an email like this from Antonio, and by the way, kudos to Antonio for taking the initiative and contacting us on behalf of his brother who's struggling. I mean, John, a stroke it's a major life event. It's a huge life event, and you can see that just from that brief email. You know, the only mistake that Antonio had made here is trying to appeal that denial, and we've talked about that, and we see this time and time again. The good thing is that we can help him. As long as the doctors, and in this case, I assume that's in fact what they're saying, as long as they're saying that he cannot work, he cannot return to his occupation, frankly, to any occupation, given his condition, then we can help him. And the way we help him is we start a legal claim, and we're not going to, sign Antonio's brother up and then forget about the case for another year or two. We're going to act immediately because there's urgency here. And the urgency is that there's no money coming in. And you can see that it's taking both a mental toll and a physical toll on Antonio's brother. So we can 100% help. This is not an unusual situation. And for anyone out there who's contemplating, maybe I should appeal this denial, maybe I should take my chances, I will tell you, try and Google how many times these appeals are successful. You're not going to find statistics because insurance companies don't provide those statistics. I don't even know if they have them. I think they do. But they don't want to provide those. They don't want to show that most of these appeals, that this appeal process is a sham. And so, in a case like this, that it's really straightforward from what I can see here, we can easily, in my opinion, help Antonio's brother, and it's not going to take long to resolve.
The number to reach out again, 1-855-821-5900. Email help@disabilityrights.ca. I think we'll get to this one, guys. Shirley writes in, says, my husband was injured during a hockey game and had to have surgery on his back. He's been off work for over 6 months. Initially, he received EI sick benefits, but then he applied for LTD, long-term disability. His claim was rejected because of insufficient medical documents. I don't understand that. His doctors have said that he will need to be off work for quite a long time to recover. His injuries are very serious, and he has a pretty demanding work schedule as a truck driver, which he definitely can't return to anytime soon. What can we do?
Well, we can start a legal claim. There doesn't seem to be any doubt about that. Somebody who drives a truck and has had back surgery isn't going back to work anytime soon.
No.
You don't need to be a doctor to understand that. That's just common sense. But certainly the medical opinion helps as well, too. But let's go back to this reason that they've provided for denying this claim. Insufficient medical documents. It's insurance doublespeak. They're just really, they're throwing a phrase out there and they're saying, well, that's why. It's just this phrase with insufficient medical. You can say that about any situation, and what's sufficient and what's not. Well, it's insufficient to satisfy the insurance company apparently, but who cares? Common sense tells us that this is somebody who is not able to return to work. Their doctors are saying that as well too. So there's absolutely no basis for the insurance company to say that there isn't enough medical evidence here. They know that there's enough medical evidence here. So why have they come to that decision? This comes down to the basic motivation of insurance companies. And we know this. Insurance companies are corporations. Corporations have shareholders. The corporation is in the business to make profits for their shareholders. That is it. How do they make profits, John? It's very simple. You take in more benefits, you pay, or you take in more money from the claims. You pay out less on benefits. Sure. It's as simple as that. The less money they pay out, the more money they have for their shareholders. And so their objective, from the top all the way down to the adjusters that are handling the claim, is to cut off as many people as possible and to deny as many claims as they can out of the gate. And if they've come to that decision, if they've found some justification, whether it's insufficient medical documents or you haven't met the test for disability or for totally disabled, whatever their rationale is, if they've come to that conclusion, they're not going to change their mind unless you force them to do it. How do you force them to do it? It's very simple. You take the power to make the decision out of their hands. And the only way to do that is to bring a legal claim. If you appeal it, you are allowing them to maintain control over the entire process. And they do. The appeal process isn't some independent process that you go through. It's not as though when you bring an appeal, all of a sudden it's going to this independent arbitrator who's going to take a look at it and give you a fair shake. You're appealing to the same people that have made the decision in the first place, the same ones that are ignoring what is just plain common sense. Don't do that. You start a legal claim now, and we get it resolved as quickly as possible.
Usually, and with the insufficient medical documentation, most medical practitioners that you've dealt with are pretty forthcoming, right?
They are.
More?
They are. And they give all the information the insurance company needs, but the insurance company chooses to ignore it.
Right. 1-855-821-5900. That is the number we're going to leave you with again this week. You want to send an email along. It is help@disabilityrights.ca. Shorten that to disabilityrights.ca. And that's a resource to find past TV shows and a radio show as well. And you want to go to pocketemploymentlawyer.ca. A lot of information there as it pertains to disability as well. So have a look at that at your leisure. We'll catch you again on the Disability Law Show. Thanks for joining us.